So thank you all for being here tonight for the webinar. So to start us off, I'm going to begin to give you a brief overview of the biosphere as the hosting organization, just in case anyone is new to the biosphere and isn't too familiar with us as an organization. So the biosphere has been recognized internationally as a region of global significance due to its unique ecosystems and rich biodiversity. As many of you know, we're located on the north shore of Lake Erie in southwestern Ontario, and we are known as one of Canada's most ecologically diverse regions. There is a mosaic of unique coastal wetlands, old growth Carolinian forests, oak savannas, tallgrass prairies, and the world's largest freshwater sand spit, which stretches 32 kilometers into Lake Erie, home to over 1,600 different species, including over 400 bird species, with that sand spit acting as a very important stop for migrating birds. And there are over 1,300 plant species supported by this unique array of ecosystems, including but not limited to many species at risk and many rare species as well. Overall, the biosphere is an important hotspot for biodiversity that is incredibly unique to this region, but also this region's farmers, woodlot owners, and other rural property owners have been taking pride in practicing land stewardship and have been valuing this natural abundance in this part of Ontario for many decades, if not centuries now. And conservation action in this region dates back to 1866, which is actually 27 years before Algonquin Park was created, which is one of the most famous provincial parks in Ontario. So, a hotspot for conservation for decades and more to come. This global recognition comes from being designated as a UNESCO World Biosphere Reserve, which happened in 1986. As a result, Long Point is part of a global network of more than 750 biosphere reserves, of which 19 are in Canada and 4 of them are in Ontario, including Long Point. And then us as the organization, the Long Point Biosphere Region is the charitable nonprofit organization that was established to uphold the values and vision of the UNESCO Biosphere designation. So biosphere regions are chosen and designated by UNESCO's Man in the Biosphere program to demonstrate how communities can combine biodiversity conservation with sustainable community development by enhancing the relationship between people and their environments. As an organization, we do this through a fairly straightforward mission and vision. As an organization, we do strive to collaborate to enhance ecosystem and community well-being and unite people with nature through a vision of having all things thriving together within the biosphere region. In order to have achieved this designation through UNESCO, a biosphere region must be able to demonstrate how its communities combine biodiversity conservation with sustainable community development through the integration of 3 main functions, which we as an organization have been demonstrating leadership in each of these. So the first is fairly obvious: conservation of biodiversity and cultural diversity. Many of you are probably familiar with, we have a road ecology program where we mitigate road mortality for many species at risk, like Blanding's turtles. We also have a turtle hatchery, so we are helping to rescue those turtles and release them back into the wild. Pillar number 2 focuses on economic development that is socio and culturally and environmentally sustainable. So we do this through programs such as our Coastal Resilience Project, which engages landowners with using nature-based solutions to fight shoreline erosion. And pillar number 3 focuses on logistics support through underpinning development through research, monitoring, and education and training. So examples like this webinar is meant to serve as an education opportunity. We also work with school groups to deliver nature-based curriculum, and we do interpretive guided hikes and all of that sort of stuff as well. And finally, in Canada, some biospheres have adopted a 4th pillar pertaining to reconciliation as it relates to our cultural history in this country. We, as an organization, are continuing to work towards this pillar by deepening our learning about Indigenous knowledge systems and developing meaningful relationships with Indigenous peoples, organizations, and First Nations. To date, we have partnered with the Mississaugas of the Credit First Nation on art installations as part of a project known as the Moccasin Identifier Project, which aims to raise awareness about treaty responsibilities and the history of the land. So, a little bit about me to introduce myself and kind of what brings us here today. So, my role with the biosphere has been to help advance the recognition of protected and conserved areas within this region. So across the biosphere, there are currently 158 properties covering just over 11,000 hectares that have been formally recognized for their conservation and stewardship efforts. But all of these properties are held by conservation organizations such as the Conservation Authority, the Land Trust, Nature Conservancy Canada, and Ducks Unlimited. And we love partnering with those organizations. They're wonderful partners. They do great work. At the same time, though, we know that stewardship in this region has largely been led by landowners, and we want to better support our landowner community as well, and not just the work of these larger organizations. So farmers and rural landowners have been managing this land for a long time in ways that both support agricultural production and also the conservation of biodiversity. And that's essentially what makes this region special and unique to what it is. So both of those two things work together in a synergy rather than in conflict. And then as development pressures continue to grow across the province, we want to be able to support landowners who are interested in protecting what matters to them while continuing to farm and manage their properties as they know best as the original and natural stewards of this land. Just earlier this year, we did partner with the Ontario Farmland Trust to host an event called the Farmers Breakfast event. So this was focused on raising awareness on farmland loss in southwestern Ontario and in particular Norfolk County, and to talk about options available to landowners who want to plan ahead and protect their land. And one of those options is conservation easement agreements, which is a tool that can help landowners protect their property while continuing to farm and manage it. So I just sort of gave you my overview and bio of who I am. So now I will introduce to you our speaker. So we are joined here today by Paul Peterson. Paul is a lawyer with over 30 years of experience working with land conservation organizations, landowners, and governments on private land conservation projects. Paul enjoys advising landowners on achieving their personal objectives for the future of their land. His work has covered forest, wetland, and farm properties in Ontario, as well as large grassland ranch projects in the prairie provinces. In private practice, Paul has worked for many years providing legal advice to landowners and municipalities on land planning and development, including the development of the Blue Mountain Village near Collingwood. And lastly, Paul has worked in recent years with the Nature Conservancy of Canada, advising on issues of property acquisition, land management, and disposition across the country. And I have had the pleasure of attending many webinars hosted by Paul. He's a very engaging presenter and has a wealth of knowledge to share with us. So without further ado, I will hand it over to Paul.
Thanks very much, Rachel. We can move to the next slide. I'll ask you to do that each time. Although Rachel promised that I would be an engaging speaker, I start by pouring cold water on things and saying that I have a legal disclaimer. This presentation is not legal advice, it's just general information. And we'd ask you to please take it in that spirit. If you were pursuing a land conservation project, you'd have to work with your own lawyers to get the advice you need. Please go to the next slide. So plunging right into the subject at hand, what is a conservation easement agreement? It is a legal agreement and it gets registered on title to the property. You might be familiar with easements. I remember many years ago, I lived in Toronto and I had a mutual driveway easement with my neighbor so that we shared a driveway on part of a property. So that was an access easement that was registered on title and no matter who owned the land in the future, it ran with the property. In this case, we're not establishing that kind of access easement, but it's an instrument registered on title to protect agricultural land, wetland, forest, wildlife habitat. Uh, Rachel mentioned the large ranch conservation agreements out on the prairies. And interestingly, the different types of agriculture compete for the land there. The ranchers love to keep their land in grassland, and so do the conservationists. So the uh, conservation agreements there will often say no no plowing or destruction of the native grassland, because both the ranchers and the conservation people are trying to keep what is left of the grassland out on the prairies. Next slide. And the purpose is really, it comes, we'll talk about the financial implications in a few minutes, but this really is a philosophical or emotional decision for landowners. It's looking ahead. And if you've been a careful steward of your land and you are thinking you want to keep it that way in the future, you want to make sure that it's not developed or broken up, um, then you can use one of these agreements registered on your title to ensure that agricultural values and if you have wetlands and woodlands, the natural values will be preserved through future generations. Next slide. So this is really important. The land remains in private ownership. The landowner or the farmer is still in charge of the day-to-day management and all responsibilities for the property. Uh, it can be sold, leased, mortgaged, or passed on to heirs. Uh, I'll just mention that if there's a mortgage on property already and there's an effort to put a conservation easement to be registered on title, then we typically ask that the mortgage be postponed. That is, it's put in second place to the conservation easement. And even the mortgage company, if they ever took possession of the land, would have to comply with the conservation easement terms. I've mentioned the last point a few times that conservation agreements, once they're registered on title, run with the land title and will be legally binding on future owners of the same land. We have just a small group of people with us this evening. If you do have questions, you can find the chat function at the bottom of the screen and ask questions as we go if you like to do that. And as Rachel mentioned, we'll have a question period at the end as well. Go ahead to the next slide. So we mentioned the landowner still owns the land, but how is the use of your property affected? Um, One of the strengths of the conservation agreements is that they can be tailored to the individual properties, but it will impose land use restrictions. It might permanently protect wetlands and forests, so there will be terms in the agreement that say no drainage of the wetland, no cutting of the forest, or limitations on cutting of the forest. Um, there'll be permanent protection of agricultural land so that it can't be subdivided or turned into new housing lots. Uh, and part of the effort to tailor make the conservation agreement to each property is that you can identify the features on the land. If you're looking at a 200-acre farm, you might have a 40-acre protected natural area of forest and wetland in one corner. That would be identified in the conservation agreement. If there's a 5 or 10-acre area for barns and buildings, whether they're existing or to be built in the future, you can identify a 5 or 10-acre building area. And then the balance of the land, 150 acres, would be designated as agricultural land to be kept in agricultural use and not to have buildings on it. I just gave those figures as an example, but you can use those ideas of zoning and land areas flexibly to get exactly the outcome you want on each property. That's good. Next slide. And about access, I used the example of a driveway easement early in the presentation. Uh, the land trust or conservation organization that holds the conservation easement, that's the beneficiary of it, will have a right of access over the property so that they can check, monitor, and ensure that the landowner is complying with the agreement. Um, there's an understanding that they're not, usually those visits happen once a year, and they usually happen with notice to the landowner. So it's not intrusive. There's not going to be people visiting every week to see how you're doing, but there is a right of access to the property to make sure there is compliance with those land use restrictions that we just described in the previous slide. Public access, typically no conservation easement is not granting a public right of access. It's just the land, just between the land trust or the conservation organization and the landowner. Um, we have seen cases where public access is permitted, maybe on the Bruce Trail or something like that, but that's not usual, and it would be specifically, the landowner would have to specifically agree to that. Next. As far as if you're a landowner thinking about doing this, who is on the other side? Who is the conservation organization that holds the conservation agreement? It can be a local, a provincial, or even a national nonprofit organization. The Long Point Basin Land Trust is a local organization that could perform that function. I don't think that that local land trust currently owns any conservation agreements, but that's the type of organization that could do it locally. Governments and conservation authorities can hold these conservation agreements. Um, at a provincial level, there's the Ontario Farmland Trust. I don't know if they have a dozen farmland easements across the province now, maybe more. I spoke to their executive director last week, and I should have asked them that number. But they are working across the province on easements, specifically, as the name implies, for farmland protection. And nationally, you have organizations like Ducks Unlimited, who have been historically active in the Long Point area, along with Nature Conservancy of Canada. So those are the organizations that can hold it. Typically, there's a paid staff and a volunteer board on the land trust, and they're typically, I think every example I referred to, even the conservation authorities, the government organizations, can issue charitable donation receipts if there's a gift component to the transaction. Next slide. I'm going to jump ahead to a topic because I started talking about money and gift receipts, and I think it'll come up in a minute on another slide. But I wanted to say that typically we are talking about donations of the conservation easements. Um, I don't think there's a lot of funding in Southern Ontario to purchase these or to provide any compensation. We're typically looking at a donation, and we'll talk in a minute about the appraisal values and how that works. But looking at that big question, could a conservation easement be the right choice for my property? We had a list of questions here for you to consider. Um, do you want to protect the agricultural values in the long term, beyond your own term on Earth? Do you want certain natural features, wildlife habitats to be protected, and yet let the land remain in private ownership? You can protect scenic and historic values. And could you benefit from income tax deductions for estate planning or even during your lifetime? Do you want income tax deductions that could be generated by the donation of the conservation agreement. If you've answered yes to some of these questions, then it may be worth further investigation on your part. Um, Even though they're donated, I've certainly worked with a number of landowners who've been quite happy with the outcome. I'm thinking of a large example of a property that was cottage property, not farmland, but the landowners were 90 years old and they'd owned the land for decades. It was waterfront property near Kingston, Ontario, and the capital gains on that valuable waterfront property, and they had thousands, a couple of thousand feet of water, beautiful lake frontage, was tremendous. It was very, very high capital gain tax liability they were going to face, or their estate was going to face. They loved the property the way it was. They made a gift of a conservation agreement on that forest and waterfront property to basically wipe out the land development value so that the land would never be turned into shoreline cottage lots. And the value of the conservation easement donation wiped out their capital gains tax liability on the property, so that they were able to convey it to their family, and they actually did it to a family corporation so that the family could own it forever without future estate turnovers. And they were able to make that transfer without capital gains tax liability because the conservation agreement had taken care of that capital gains liability and offset it. So it can work very well. The landowner gets the long-term protection of the property they want and potential big benefits for estate planning. Next slide. I've already mentioned the idea that we're mainly talking about donations of conservation easements, and how that works in practice is we retain professional appraisers, and they look at the value of the land today. I'm just going to use sample numbers. If the land is worth $10,000 an acre unencumbered, just as it sits on the market or in the market today, and then consider what would that same land be worth if this conservation easement said you couldn't build anything on 195 out of the 200 acres. You can't build anything, you can't subdivide it, you can only use it for forest and agricultural land. In that case, the land might only be worth, again, I'll just use sample numbers, $6,000 an acre. And the difference, the reduction in the land value caused by the conservation agreement land use restrictions, that's considered to be the value of the conservation agreement. And that's the value of the donation receipt that would be issued to the landowner. And typically what happens is that once the appraisal is done and the parties get to review it and accept it, they don't have to go into this blindly. Once the appraisal is done and you have that value, then the land trust can issue a donation receipt, a donation tax receipt for that amount. Just let me think about that. In the example I did, I said $10,000 an acre for 200 acres. I think that's a $2 million property, and $4,000 an acre for that would be an $80,000 donation receipt. I think I've done that right. If someone who's more mathematically quick could correct me on that. But if the conservation easement was worth 40% of the land value in the example we used, then there would be you'd have a $2 million property, but there would be an $800,000 donation tax receipt. Let's go to the next slide. And I already covered the first point and using the same sort of 40% approximation of a conservation easement value. And it works differently for individuals and for corporations. For an individual landowner, a charitable donation generates personal tax credits. And just very approximately, you'd have to go through the actual formula with your accountant. It might generate $160,000 in personal tax credits against tax payable. And if the landowner is a corporation, uh, the receipt would generate $400,000 deductions from the taxable income of the corporation. Next slide, please. There is a federal program. It's under the Income Tax Act. The example I used would work whether it was an ecological gift or not, but there are some enhanced tax benefits available through the Ecological Gifts Program under the Income Tax Act. The land has to qualify as ecologically sensitive. Without getting into precise details, you'd have to run this through the ecological gift staff at Environment Canada. But if there are valuable wetlands and woodlands on the property and other parts of the property are cropland, it's possible the entire property would still qualify for the ecological gift treatment. And pardon me for diving right into the weeds on tax treatments, but if it's an ecological gift, then the entire amount of the gift can be used in the first year of the gift. Typically, there are restrictions on, I think it's up to 75% of an individual's income can be deducted. In the example we had, if someone had income of, pardon me, let me not go that far. The entire $400,000 amount of the donation could be used against income in the year of the gift if it's an eco gift. And the unused part, say you only needed to use $200,000 of the donation amount in the first year to deal with income tax liability, you can carry forward the $200,000 that wasn't needed and wasn't used. With it normally, I think you can carry the unused donation amount forward for 5 years, but with an ecological gift, you can carry it forward for up to 10 years. And there's a third benefit to the ecological gifts program. There's no taxable capital gain on the disposition of the interested land. I'll just spend maybe a minute on that point, and I'll get you in the right frame of mind by saying that 20 or 30 years ago, there was a publication called You Can't Give It Away. And it was criticizing the idea that under Canadian income tax law, even when you made a gift of property, such as a conservation agreement, you were liable for the capital gains tax liability on the gift. Under the Income Tax Act, it was simply a disposition of the property. And whether you sold it or you gave it to your family member or you made a gift to a charitable organization, they were all dispositions and they all triggered capital gains tax liability. If it's an eco gift, there's no capital gains tax liability attached to that part of the property value at all. I'll just say that if you proceeded without an eco gift, you would still have some income tax benefits because the tax donation receipts will offset and exceed, in most cases, you'd have to talk to your accountant, but would offset and exceed the amount of the capital gain liability on the disposition. Let's go ahead to the next slide. If you were thinking about this and want to know how does it work, what happens, who does what, there are quite a few steps here, and I'll have to say even this is a little simplified, but at a high level, here are the steps that you would engage in to get a conservation agreement done. Just initial exploratory meetings to see if the land trust and the landowner agree on basic principles of what they want to protect and what they want to do. You would schedule a site visit. The land trust staff would come out and walk the property with the landowner to make sure they understand and agree on exactly what is happening. The land trust would develop a work plan and a budget for the project. They would obtain a preliminary title report. I mentioned before that if there was a mortgage on title, for example, the land trust would ask that a mortgage postponement be obtained before the conservation easement was finally registered. That doesn't mean you have to pay off the mortgage. It just means it goes in second place to the conservation easement on title. And I've seen mortgage companies agree to this. It's a step that is required, but it's not something they haven't seen before. And then there's the detailed work of actually negotiating and signing an acquisition or donation agreement. Typically, in very short summary form, what it says is I, the landowner, agree to donate this conservation agreement, and there'll be language about the title search and the timing and all of the details. And the conservation easement will be attached as an appendix saying, I agree to donate a conservation easement in the form attached. You need to have the conservation easement so that it can be appraised. And so that would be the next step. Number 6, obtain a professional appraisal. And if the project is to be an ecological gift, submit the appraisal for review by an appraisal review panel. If that sounds like quite a bit of administration and bureaucracy, it is a little administrative and bureaucratic, but it comes with big benefits. There's all the ecological program benefits that I described, but there's also the benefit of having the government sign off on the appraised value of your transaction before you do it. By the way, I'll just, on a brief sidebar here, in the United States, which does everything in its own way, there was a huge problem of people doing fraudulent appraisals on conservation easements and cheating the tax man with their appraisals. And people I talked to, lawyers and administrators of conservation programs in the United States, said they were actually jealous of the ecological gift program in Canada and the fact that we had this appraisal review panel so that everybody knew what to expect before the transaction went ahead. So that would be step number 7. And next slide. There are costs involved in doing a project like this, just the registrations, the lawyers, the appraisers, and sometimes there are other costs related to the assessment of the features on the property. So the land trust has to secure project funding. Oh, and typically, if the land trust is acting responsibly, they will want an endowment fund or a stewardship fund to make sure that they can keep doing their work of monitoring the property and enforcing it. So the land trust will raise money and put it in an endowment bank account at the beginning so that they have the funds available to run this project in the future. They prepare something called a baseline condition report. You can understand that the conservation agreement might say no buildings on the agricultural land. We need documented evidence that there aren't any buildings there right now. Or if there's an old barn shed falling down, we want a record of it so we know whether the agreement is being complied with. If it was ever necessary to enforce the agreement in the future, you need to be able to say, here's the easement, no buildings. Here's the baseline report, there are no buildings. Where did that building come from? So it's just a matter of preparing the background information and evidence so that the whole conservation easement uh, project can function in the future. Um, Number 10, a little legal technicality, satisfaction of conditions in the acquisition or donation agreement. So, as I mentioned earlier, there'd be an agreement to say, we agree to donate this conservation easement, but it might have been on conditions. The landowner condition might be the appraisal is acceptable to me and the appraisal is approved by the ecological review panel. So that would be a landowner condition. And when those conditions are, and the land trust might have had a condition that said, we are able to raise $100,000 in endowment funding. So you would each have conditions, and only if those conditions are satisfied do you go ahead to finally register the agreement. Then that brings you to step 11, finally sign and register the conservation easement. And number 12, after it's all done, the land trust issues the charitable donation receipt. And then I had a note for the post-closing period. As we mentioned, the easement consists of land use restrictions and prescriptions for future land use. So the land trust staff will conduct annual monitoring to ensure that the conservation values are still protected and there's compliance with the conservation easement agreement terms. Next slide, please. Yes, what are the landowner responsibilities and costs? Uh, they may include an investment of time. I worked once on a very large ranch conservation agreement just a couple of years ago in Alberta. It was tens of thousands of acres and extremely valuable property. And it took months to negotiate that. But anyway, it was complicated and there was a lot of time devoted to getting it right. For a 100 or 200 acre property, it's of course not that time consuming, but you do want to get the details right. You do want to be sure that you've got an agreement that you're happy with because both parties will be living with it for a long time. The landowner could have costs of consulting with their accountant to make sure that the tax implications are going to work for them. And the landowner will usually also have costs of independent legal advice on entering into the agreement. The land trust will usually insist that the landowner obtain independent professional advice. We don't want it said later that people weren't well informed. Next slide. You've heard this point a couple of times. What are the land trust responsibilities? Yes, they have to monitor for compliance and maintain a relationship with the landowner so that developments such as transfer of ownership can be anticipated. And if there is a transfer of ownership, the land trust will contact the new owners to make sure that they're aware of the conservation agreement terms. This working relationship between the land trust and the landowner is entirely up to the landowner. The land trust staff are well-intentioned and busy, usually young people. They're not hard to get along with. If the landowner wants to have an open and cooperative relationship with them, they will. The landowner that grants the conservation easement, the original landowner, is usually very interested in this project, and they have an excellent working relationship with the land trust, and generally things run quite smoothly. Problems can start. I've seen situations where the original landowner passes away, the property is inherited by a nephew or a niece who never heard about conservation easements, but is very happy to have this valuable farmland. And conflicts can arise then because they think they're going to be rich land developers or something. So the issues and the relationships become a little more strained if the landowners don't know about or want to ignore the terms of the conservation easement. But for the most part, these relationships are constructive and amicable and no one stepping on the other person's toes. Um, Next step. Yes. So when things are going sideways, how is the conservation agreement enforced? In most cases, just good communications between the landowner and the land trust will address the issues. The landowner may come with a proposal that says, I've got a flooding problem on this back field or water pooling back there, and I need to install some drainage. I understand in the sandy soil of Norfolk that might not be a common issue, but it might be something like that. It might be I need to construct a barn or a shed for some equipment or for animals, and just make sure that the building is being located within the designated building area and that everybody knows where the boundaries are. If necessary, the land trust staff would go out on site and say, yep, that's the corner of the building area. We know exactly where we are. And then life goes on. Um, where there's a disagreement or a breach of the conservation easement, parties will usually work toward a cooperative resolution. I'll talk in a minute about whether or not it's possible to amend conservation agreements, but I've seen a number of examples where the parties realize maybe 10 or 15 years after the agreement is signed, this isn't working. The buildings should have been over there beside the road. They shouldn't have been back here, halfway back in the property. We need to move the building area, or we need to make adjustments to the conservation easement. That's not simple to do, but it's one way in which there can be adjustments and resolution of issues um, going forward. And if there is a breach of the conservation easement that cannot be resolved, the land trust can seek legal enforcement remedies. There's now hundreds of conservation easements across Canada, and I haven't seen um, too many go to court. There have been a couple of court battles over conservation easement agreements, but usually uh, the people can, even if the land trust has to file their intent to file a lawsuit, where they retain the lawyers, they say, look, we're going to take this to court. At that point, rather than spend money on courts and lawyers, the parties will usually come to a resolution of the issue. Um, next slide. And Rachel, we might just say I saw in the chat someone who was joining late and had missed a lot. I don't know if you want to comment on that or what we could do to make up for that.
There's a few, she's asked a few really great questions. Um,
Okay. And
but
I'm
there's
sorry,
a,
I didn't stop. I was supposed to stop and
no,
ask
that's
you similar
okay.
questions.
She just posted her question now. Yeah, really
Okay.
great questions. But there's a few. So given that maybe we only have a few slides left, would you rather address them now or do you want to hold them for the end?
You know what? Let's stop and see if we can answer those questions.
Sure,
Sometimes the questions are holding up people's thought process, if they're stuck at an
absolutely.
earlier point.
So I can read them out for you. So there's a few. Perhaps I'll go one at a time. And yes, some of this material we have discussed, but great refreshers. So no worries whatsoever. The first question is, what are some examples of land use controls? So I imagine the covenants that you may typically find in a agreement.
Sure. Um, so if the protected feature is simply the agricultural land, the cropland, then the land use controls might be fairly limited and might simply say no construction of buildings uh, or storage of equipment. I mean, we've seen some properties turned into storage areas for boats and trailers and God knows what. So it might just be anything that would stop the land from being used for cropland. So it could be quite simple on the cropland area. If it's woodland, swamp, wetland area, the restrictions would typically include no buildings, no drainage, no cutting of no commercial forestry operation to remove the forest. Uh, it's interesting. You'd have to negotiate with a landowner and think about the property, whether you would have a prohibition on livestock in the woodlot and swamp. Um, I would want to know more about the local geography and land use to know whether that would be appropriate or not. But whatever it would take to protect that feature.
So another question, actually, just to jump to another participant because they've asked a question that relates to this, is um, wondering if it's okay for hunting and the harvesting of firewood on the property.
Those are detailed points that are, as we said earlier, each agreement is tailored to the needs of that property and to the parties involved. So on hunting, I rarely see a hunting prohibition in a conservation easement agreement. If you think about the land trust only being there maybe once a year to monitor, the land trust can't really monitor and enforce a hunting prohibition. So I discourage land trusts from including that. But sometimes it's the landowner's fervent wish that maybe they know that it's a winter deer yard area or it's a habitat of some other species, and they hate the idea of people coming to hunt there. Sometimes the landowner wants uh, a wildlife protection area and wants a hunting prohibition. And you would just have to talk through how to, that's primarily up to the landowner to post the no hunting signs. It's hard for the conservation land trust to be, they can't be there every week to monitor hunting. But that's a detail that would have to be worked out. Firewood, many conservation easements say something like no commercial forest harvesting, but the removal of up to, 2 cords or 4 cords, full cords of firewood each year for personal use is permitted. So you have a prohibition on commercial logging that would clear cut the forest, but you have an allowance for personal use. That's a common resolution of that issue.
All right. And I think I can't remember, Paul, if you've mentioned this, but another point that might be of interest is sometimes, from my experience, I've seen conservation easement agreements where the property is broken up into different zones. And as a result, there's different land use restrictions in different zones. So, talking about livestock, like you said, for example, earlier, that would be more so relevant to some zones rather than the others, right?
Yep, absolutely. You can tailor make it. You always want to be a little practical too, though. You don't want to be overly prescriptive and overly detailed about exactly what is allowed or not. Like something like if you do a baseline report and you know there's no buildings in the woodlot or the cropland, and you have a no building prohibition, that's relatively easy to monitor and enforce. Um, I've seen conservation easements that said, I, no campfires, no pets, or no dogs off leash. I, I hope, I wish those would never happen because it's too detailed and you can't enforce it. So there's an interesting discussion around what kind of restrictions are appropriate.
All right. So the remainder of those questions, we sort of just gave some examples of this, but it was asked, what are some examples of land use controls? So we've talked about a few different examples of land use covenants, but I'll let you discuss any more you think are relevant. And then the rest of the questions are, does the agreement require any active management or just leaving the area alone? And then, yeah, I'll let you address that. And then there's
Okay.
one final question.
Um, one other thing about the types of land use restrictions, typically restriction number one is no subdivision. We don't want the land if you're dealing with a 200-acre farm, maybe the municipal planning documents would allow for the division into a number of lots. Typically, the conservation easement will prohibit that. It could allow it, but typically we don't want that. If a 200-acre farm is divided into four 50-acre pieces, typically each new landowner will have the expectation that they need their own driveway and their own septic field and their own house and their own. So suddenly it's development pressure, right? You want to back off the development pressure on these agricultural and natural lands. So we try and limit it to a single building area and no subdivision. That's another interesting uh, land use restriction that is typically imposed here. Um, Oh, I'm sorry. What was that?
No,
The second part of
no
that was
worries. Does the agreement require any active management, or
oh,
does it just
active
require leaving it
management.
alone?
Yeah. This is a really interesting question. And I'll start for lawyers. And in English common law, there's a big distinction between restrictive covenants that prevent you from doing something and positive covenants that compel you to do something. So we typically try and avoid covenants that are positive and oblige the landowner to do something. They're just harder to enforce, and that was the old English common law rules. Judges didn't like positive covenants and didn't like having to make landowners do things. Let me talk again about the prairies. And in the because I've worked on so many there, but typically the restrictive covenants will say no building, no plowing up of the native grassland. And there's a fervent desire of the ranchers and the conservation organizations to protect the quality of the grassland. And but we work hard not to have those positive obligations included in the covenant. They're typically better off in the um, in a separate agreement, like a stewardship agreement. Yeah, on the positive and negative covenants, the conservation easements are stronger and more enforceable on the negative covenants. When it comes to positive covenants, like best land management stewardship practices, those are maybe better dealt with in other agreements, ALICE type agreements, stewardship agreements. Um, the Weston Foundation has a fabulous program on the prairies of grassland stewardship support. But that's done, it's sort of compensation to the landowners to assist them in undertaking best practices. So we can have positive obligations in conservation easements, but they're not used as much. One example might be fencing to control livestock if that was desirable. There could be an obligation to maintain fencing.
All right. So the last question here before we move on to the final slides, um, is what qualifies an area as eligible for an easement and who is doing that qualification? Is it the specific land trust or organization that would be holding the easement?
It's twofold. It's usually the land trust conservation organization that decides whether it's worth their effort because there's quite a commitment and effort by the land trust organization into setting one of these up and managing it in perpetuity. Um, so they decide, but then if it's going to be an ecological gift and qualify for the enhanced tax benefits, then there is an additional approval required by the ecological gifts program that it qualifies as ecologically sensitive land. This it doesn't have to be the most sensitive piece of habitat land in Norfolk County to qualify. If there are habitats and wetlands and woodlands, uh, there's a good chance the property would qualify. And for the Conservation Land Act, that's the Ontario legislation that governs this, also has a category for agricultural land. And the Ontario Farmland Trust is just looking for easements on farmland. So There is a qualification threshold, but it's not impossible to cross that threshold.
All right, so I will take us to the next slide.
Did we cover that previous slide? Sorry, we're almost going to run out of time. Did we cover the slide about amendment?
Mm,
I
that is
don't
a
think we did. I talked about the idea that that's one way to remedy a problem, but it's a question that landowners ask. There's an emphasis on this idea that it's permanent protection. Can it be amended or revoked? Um, they're not easily amended or terminated. In Ontario, you need approval from both the provincial government and, if it's an eco gift, from the federal Ministry of Environment. So they can be amended, but there better be a good reason. And typically, the government and the land trust will be looking for an outcome in which the conservation values are protected at least as much as they were before. Let me give you a concrete example. I did an amendment in Alberta when I think it was a 160 acre quarter section of land. The building envelope was right in the middle, and the owner said, "This is in the wrong place. I want to move my building envelope beside the road." So it was an eco gift, and the federal government eco gift panel approved the amendment because the situation would be improved. The building envelope shrunk, and I'm just going to make up numbers from 8 acres down to 4 acres, and it was moved to the periphery of the property and outside of the main habitat area. So there was an amendment that the land trust organization agreed to, the Environment Canada staff could agree to, because the protections of natural values were actually enhanced by the amendment, and the landowner got the building envelope that they wanted. Okay, next slide. This is just here for reference. I've referred a couple of times to the Farmland Trust. The Ontario Land Trust Alliance has a publication on conservation easement agreements. The Canadian Ecological Gifts Program Handbook is a terrific document explaining that program and a lot of ideas that are central to this conservation work. And we had a last bullet on the legislation, the Ontario Legislation Conservation Land Act, that allows these agreements to be put in place. Next. And maybe we'll take time for questions, but go to the last slide. Thank you, just so people know how to follow up with us if they want to. So I think we're at or past our allocated 1 hour. For anyone that's still here, we'll certainly stay and deal with any questions. At some point very soon, Rachel is going to turn the recording off, and some people don't want their questions recorded. But I'll just mention as well that as part of this little initiative with Long Point Biosphere Reserve, we do have some time to consult with landowners or interested parties privately. After this webinar is done in the next couple of weeks, if you wanted to contact Rachel or myself and just ask questions applying to your circumstances, then we have time and availability to do that as well.